The admissions coordinator finished explaining the monthly fee, handed you a folder with somewhere between 12 and 18 pages inside it, and somewhere between the parking lot and the car, you realized that nobody had walked you through what you had just been handed. The folder contains the agreement your loved one is about to live under, and 5 of the clauses inside it are written specifically to limit what you can do when things go wrong. By the end of this video, you will know which 5 clauses to locate before you sign anything, and you will know the one move that costs nothing and takes under 2 minutes that most elder law attorneys say families almost never make. There is a reason these clauses are placed on pages 11 and 12 of a document that facilities know families are reading in crisis. The system is not designed around your loved one's protection. It is designed around limiting the facility's exposure when protection fails. Nursing homes and assisted living facilities across the country use admission contracts drafted by a small pool of senior living industry law firms, including Nelson Mullins Riley in Scarborough, based in Columbia, South Carolina, and Polsinelli, based in Kansas City, Missouri, firms whose client lists map directly to the major national chains. The clauses those firms have refined over decades appear in contracts from California to Maine with the same structure and the same intent. Here are the 5 your family needs to find before the pen touches the paper. The first is the pre-dispute binding arbitration clause. This clause, typically appearing under the heading Alternative Dispute Resolution, requires your loved one to waive the right to a jury trial before any dispute has occurred and before any harm has been done. The Centers for Medicare and Medicaid Services, headquartered in Baltimore, Maryland, issued a federal rule in 2016 prohibiting nursing homes from making arbitration a condition of admission. In 2019, CMS reinstated a modified version of the rule, codified at 42 CFR section 483.70, requiring the arbitration agreement to be physically separate from the admission agreement, that residents be told in writing that signing is voluntary, and that residents have 30 days to rescind. Most facilities still present the clause as if it carries the same weight as the mandatory paperwork. Arbitration disputes are resolved by a private arbitrator. Hearings are conducted in secret with no public record, and the arbitrator's decision is binding, with extremely limited appeal rights. In wrongful death cases involving documented care failures, plaintiff attorneys in California, Florida, and Ohio have documented that arbitration awards run 40 to 60% below comparable jury verdicts. That is not a coincidence. That is a business model. The second clause is the rate increase provision. In California, Aegis Living, a Bellevue, Washington-based assisted living company, agreed to a $16.25 million settlement in 2021, approved by a federal court in the Northern District of California in Oakland, resolving claims that residents had been charged fees based on a care assessment point system, while the company allegedly staffed its facilities based on budget targets rather than actual assessed care needs. The lawsuits, filed in both California and Washington, alleged violations of elder abuse and consumer protection statutes. The mechanism is this: a resident enters at a base rate. The contract permits increases when assessed needs change. The facility controls the assessment, and there is no independent review requirement. Families who did not notice the clause have described increases of $2,000 to $4,000 per month within the first year. The third clause is the discharge and transfer provision. Federal law under the Nursing Home Reform Act of 1987 gives residents the right to contest a discharge, but the discharge clause attempts to expand the facility's discretion beyond what federal regulation permits. Clauses citing failure to pay, inability to meet care needs, or behavior affecting other residents are common. The specificity of those phrases matters, and most families never ask for definitions before signing. The fourth clause is the financial responsibility provision. This clause attempts to make a family member personally liable for fees when the resident's own assets are insufficient. The Nursing Home Reform Act and its implementing regulations prohibit nursing homes that accept Medicaid or Medicare from requiring a third-party guarantee of payment as a condition of admission. The Consumer Financial Protection Bureau, based in Washington, D.C., documented in a 2022 report that 72% of legal aid respondents had seen admission agreements containing language that made third parties personally liable for nursing home debt. Families who sign it without noticing often discover its consequences only after the bills stop being payable. The fifth clause is the care plan modification provision. This clause gives the facility authority to alter services based on internal assessments, often without requiring family notification before the change occurs. The clause is framed as operational flexibility. What it actually authorizes is a unilateral reduction in services with no external accountability mechanism. This kind of information used to require hiring an elder law attorney to find out. If you want to keep getting it for free, subscribing is how you make sure you do not miss the next one. I have looked at a lot of these admission contracts, and the clause that appears in almost all of them, that most families never notice, is not the arbitration provision, which has received some press, but the care plan modification clause, because it is the one that allows everything else to happen quietly before anyone realizes anything has changed. The 5 clauses in this video do not come from 5 different legal traditions. They come from one. The American Healthcare Association, headquartered in Washington, D.C., has spent decades opposing federal standardization of admission contracts. That absence is not an oversight. It is the product of sustained industry advocacy. The clauses migrate from one chain's contracts to another through the same law firms, the same trade conferences held in Orlando and Las Vegas. The part of this that most people miss is not the individual clause, but the distribution system. Because the distribution system tells you that a family walking into an admissions meeting in Phoenix, in Pittsburgh, or in Portland is likely facing the same 5 clauses with minor surface variation and identical underlying intent. That is the folder on the table in front of you, or the one that already has your signature on it. Everything before this point is what the industry counted on your family never learning before you sat down in that admissions office. What follows is what they are genuinely unprepared for you to do with it. The one move most families never make. Before the admission meeting, call the facility and ask them to send the contract in advance. Facilities are not required to refuse this request. That single step removes the crisis signing dynamic the entire contract structure is designed to exploit. First, locate the arbitration provision. Under 42 CFR section 483.70, this must be a physically separate document from the admission agreement. Write declined, not a condition of admission, across the signature line and initial it. The facility cannot legally deny a bed on this basis. Time required, under 2 minutes. Cost, nothing. What it prevents: the 40 to 60% settlement discount that arbitration imposes on wrongful death cases. Second, locate the rate increase provision and ask in writing what triggers a level of care reassessment and what the maximum annual increase is. If no maximum exists, ask for that in writing. Third, locate the discharge provision and ask the coordinator to define each triggering condition in plain language. Under the Nursing Home Reform Act, a resident has the right to 30 days notice before discharge in most circumstances and the right to appeal through the state long-term care ombudsman program. Fourth, locate the financial responsibility provision and ask the facility to confirm in writing that no third-party personal guarantee is required. The federal prohibition on this requirement applies to all residents, regardless of Medicaid eligibility. If the facility declines to confirm this in writing, consult a certified elder law attorney before signing. A 1-hour consultation through the National Academy of Elder Law Attorneys typically runs between $200 and $400 and can prevent personal liability exposure running into tens of thousands. Fifth, locate the care plan modification provision and ask what written notice is required before services change. Get the answer in writing. The complete protocol takes approximately 3 hours, including advanced contract review. According to the 2024 Genworth and CareScout Cost of Care Survey, the national median monthly cost of memory care is approximately $6,160. an undisclosed rate escalation or a care plan modification without notice can add thousands to that figure within months of admission. The protocol costs nothing except the time. If you are currently navigating any of this and something in this video matched your situation exactly, share it in the comments because you are not the only one and your experience is evidence. Share this with anyone in your family who is dealing with any of this. And if you want to stay ahead of the industry rather than behind it, subscribe. The next one is something most families find out too late.